Okay. So good evening, everyone. My name is Ethan Welch. I am an attorney here at Hickman and Lauder, and I've got George Aljo here as well. He'll be co-presenting with me. Um, we'll be talking about, Medicaid estate recovery and, you know, really how can we protect the home because the home is a very important asset to many people, many of our clients. It's many times the most expensive asset that one has. And, you know, the value of the home coupled with, the intrinsic nature of the home, maybe they want to keep the home in the family. Maybe a son or daughter, wants to retain that home. Well, the there's ways of going about doing that when someone is on Medicaid or is going to apply for Medicaid. So we'll go over the ins and outs of this, protecting the home while you're on Medicaid and protecting the home, after one passes away. And so Medicaid won't attach to uh, to the home at one's death. So let's start the slides. There we go. So when is the house at risk? So there's three main, concerns when we're talking about Medicaid. That's, you know, we're trying to get on Medicaid, and is the house protected when we're applying for Medicaid for a client? Um, what if they are on Medicaid and they have this home? How do we keep Medicaid if we have to sell the home or transfer the home? Um, but the other concern is that Medicaid estate recovery, which is paying back Medicaid after one's death if you still own the home. So there's you know, three levels here. Getting on Medicaid and having a home, or retaining your Medicaid while you own the home. And then if you own the home at death, how do we protect that home? Um, the you know the home is a special asset. You know, there's special rules and regulations regarding the home that Medicaid has put in place. The home in Medicaid terms is the principal place of residence. And there can only be one principal place of residence. There can only be one home. Um, so if one has other houses, other real estate, then that other real estate would be a countable resource for Medicaid purposes. Typically, your house will often be exempt for Medicaid purposes, but not always. And we'll get into why that is. But typically, when you're applying for Medicaid, the home is an exempt resource. So when I meet with the client and we're talking about Medicaid, and we're, you know, or I'm meeting with a son or daughter that is saying, "Hey, mom needs to get on Medicaid. She needs to go to a nursing home." I typically tell them, well, Medicaid has exempt resources and Medicaid has countable resources. So we they give me a list of their resources and I can pick what's exempt. And the big one, the home, that's exempt. But as we're going to talk about a little later, even though the home is going to be exempt while that person is alive, we have Medicaid estate recovery that we're going to have to think about. So even though it's exempt currently, it's not going to be exempt later on. But for all intents and purposes here, the home is exempt. So someone can own a home and be on Medicaid. The other big asset that's exempt is a vehicle. They can own a vehicle as well and be exempt. All right.
Okay. Thanks, everyone. My name is George Aljo. I am another one of the attorneys at Hickman Lauder. I apologize in advance. I'm fighting a head cold, so if I sound a little stuffy, that is why. There we are. So,
Good timing on that.
So how does Medicaid treat your house? When is it exempt? When is it accountable resource? So your home is exempt if you live there, if your spouse lives there, or if a dependent relative lives there. And by dependent relative, we mean child, grandchild, parent, grandparent, stepchild, aunt, uncle. It's very, very broad. And being dependent simply means that they are either financially or medically dependent on being able to live in that house. You'll see this as a kind of a common thread with this and with Medicaid estate recovery. They don't want to throw people out onto the street. Not because they are warm and fuzzy and cuddly, but because throwing people out on the street means that those people are now going to be applying for public benefits of their own. So from the state's perspective, keeping people in their homes is simply a good, prudent, cost-saving measure. But here we are. We have these exemptions here for keeping the home from being accountable. The home is also exempt so long as you so long as it is your principal place of residence. So this is kind of gets to be a little bit of a fuzzy question. If somebody leaves home and they are now in a nursing home, they can nevertheless declare that their home, their house, remains their principal place of residence. Well, what does that mean? Well, your principal place of residence is the place that you consider to be your home and that you intend to reside there. So it's the intent that is important there. So we will frequently have somebody who is in a nursing home, owns a home, does not have any other relative or spouse living there to exempt it. We will have that person sign a declaration where they declare their intent to return home. Not because we necessarily think that it's in reality going to be possible for that person to return home. This is simply a way of verifying and showing that that person still considers this house to be their home and is therefore exempt. So you might hear about this sometimes where people scratch their heads. Well, no, mom or dad, they can't go home. I mean, they need the nursing home. We still have them say, yes, but we want them to say that it is their home for purposes of Medicaid accountability. So you can hit the next slide, Ethan. So now, if your house is not exempt, Medicaid considers your equity in the house as accountable resource. So your equity is the value of the home minus whatever liens or shared ownership or other sort of encumbrances that you have on the property. So if your house has a mortgage on it, the amount that Medicaid would consider it to be countable as is only the house value minus your mortgage payoff. So if somebody has a house that's literally underwater, or they owe more on it than it is worth in terms of fair market value, that house may be a countable resource, but it's a countable resource of zero value because there's not actually any equity that that person has in that house. So how do we determine what the value of the house is? Well, you could have it appraised by a licensed appraiser, and that will be effective as considering the fair market value of the house. Or you can rely on what the county auditor has evaluated the house to be in terms of its fair market value. Usually, the county auditor value is what you want to go with because county auditor typically has it valued less than what it actually would fetch on the market. But otherwise, if it's the house is in poor shape or there's some particular reason why that county determined value is too high, you can get an appraisal done to reflect the actual real world market value of the house. You can hit the next slide, Ethan.
Yep.
So here's an example. So Alice, Brian, and Carol, they're siblings. They inherit a house from their mother, a third, and a third in equal shares. Alice lives there. Brian and Carol don't live there. The house is valued at $110,000, and there's a $20,000 home equity loan on the property. So there is $90,000 of equity that's available for the property. If the house sold and paid off the loan, you'd get $90,000 in proceeds. Now, if Alice applies for Medicaid, the house is exempt because she lives there. If Brian or Carol, though, apply for Medicaid, the house would be a countable resource for them unless they can show that Alice is a dependent relative for some reason. But the house would be a countable resource, but to each of them, it would only be countable of $30,000. In other words, you take the equity and you divide it by the shares of each owner. Now, let's say that Alice, Brian, and Carol don't own the house a third and a third and a third. Let's say Alice owns 2/3, and Brian and Carol each only own 1/6 of that property. That's how their names are on the title. Then the equity value would be proportional as well. Brian and Carol would only have $15,000 of equity in the house, as compared to Alice, who has the 2/3. And I don't know if we have this specifically later on, so I'll mention it here. If in cases where you have a large number of people who own the house, you see this quite often when several siblings inherit a house. You may have 5 or more owners on that property, and they sometimes don't all get along with one another. You can show Medicaid that even though your house is is a countable resource, your equity, your share of that house is a countable resource. If you can show Medicaid that, look, my siblings and I don't get along. If I wanted to pull my equity out of this house, I would have to sue my siblings to force a sale on it, and I'd have to hire a lawyer to take it to court, and it would cost more than what I would get back in return after all is said and done. If you can show that to Medicaid, then Medicaid will consider your equity in that house to be unavailable to you as a resource. So that is something that we frequently see in Medicaid, where somebody, yes, their name is on a house, but it's a shared ownership situation, and the house they can't get at their equity in that property, and so we can get that property exempted for them to be able to get Medicaid.
Right. I think the point there is, an asset has to be available for Medicaid or for your care to pay for your care
Mm.
for Medicaid to, count it as a countable resource.
Yeah.
So availability, that comes up once in a while. Availability. If it's unavailable, then it's not a countable resource.
Yeah. That's the distinction there is between, Ethan talked about exempt resources versus unavailable resources. An exempt resource is something that's specifically exempted somewhere in the Medicaid rules. Your home is exempt, a car is exempt. Um, Availability is sort of particular on a case by case basis. For you, a particular person, this property is unavailable because of the circumstances that are applicable to that one person.
Right.
So that's the distinction there between exempt and unavailable.
So then the next point here of, you know, improper transfers and we talked about this in earlier presentations. Um, improper transfers of real estate are penalized by Medicaid. So what is an improper transfer? Just as a refresh, or if we have new people here learning about these Medicaid terms. Well, any gift of assets, whether that's cash, whether that's real estate, you transferring, you quit claiming the house to a child and applying for Medicaid. Well, that's an improper transfer. And Medicaid's going to penalize you for every $7,787 that you gift. That's 1 month of Medicaid that they won't, you know, that Medicaid won't pay for your care at a nursing home. So even though the home is exempt prior to applying for Medicaid or being on Medicaid, if you transfer the home, they're going to say, "What? Hey, you transferred assets here." So even though you transferred an exempt asset, it's still an improper transfer. The and it's only penalty, as George said before, it's you'll be penalized by the equity value, not the fair market value, not what the tax value that the auditor says it is. If there's a lien on the home, then you only look at the equity value that was transferred. Of course, there's exceptions to the improper transfer rule. And these improper transfers um, are exempted if you transfer the home to a child that's under the age of 21, a transfer to a child or to a child's sole benefit trust um, if the child is disabled. Disability is typically governed by, is this person disabled under Social Security rules and regulations? Is this child receiving SSI, supplemental security income, or SSDI, Social Security disability insurance? If they are, then yes, any transfer to that child or that child's trust would be exempt and would be a proper transfer. Um, Another big, exception is to a child caregiver who has lived in the home for, 2 years prior to a Medicaid application. And that rule is important because Medicaid essentially wants to reward a caregiver child for taking care of their parent, keeping their parent out of the nursing home for those 2 years prior to a Medicaid application. There's a lot of rules to that, for this transfer to be proper, but essentially you have to have the documentation proving that Yes, the child lived there. The child provided the care that was needed to keep the parent out of the nursing home. And you need a doctor's evaluation to do that. You need the proof of that this child has lived there and proof that this child had been taking care of the parent. Um, even even though you might meet those regulations, if you don't have the documentation proving that, then there's no way that Medicaid will allow for that transfer to occur. I've had some clients saying, "Well, Ethan, I've taken care of my mom for 4 years." Well, have you lived in the home? Well, I've only lived there for 1 year. Well, even though I was working, you know, I took care of my parents for 4 years. After I got off work, I went straight there. I spent the night there for years, but you didn't have the documentation proving that you did live there. Um, so it's much harder to prove that, and a lot of these caseworkers are really sticklers about this rule. Um, or they never got a doctor's evaluation done saying that, you know, if it was not for this child living in the home, then, you know, this parent would be in the nursing home. There's no medical documentation proving that. And then the other exception here is, which comes up once in a while. Sometimes there's a sibling that is a co-owner in the home and who has also lived in the home for 1 year prior to a Medicaid application. So these transfers to a caregiver child or a sibling, one important, distinction here is, and typically this is how it works, is you don't do a transfer prior to the Medicaid application. You have to provide the evidence to Medicaid of the caregiver child or the sibling that has lived in this home. And after you provide that proof and after the person has been got approved for Medicaid, then the transfer to the child caregiver or the sibling would occur. Not prior to, but after. So you basically need to get the county's blessing that yes, this is proper, and now you can transfer. Um, Another way to save the home that we frequently implement for our clients is we do Medicaid planning, where we might gift the home, as an intentional gift. We're doing an intentional improper transfer. If you wait 5 years after that transfer, Medicaid doesn't see that transfer to the child or to a trust, an irrevocable trust, because Medicaid has a 5-year look back period. So this 5-year look back period is, well, they look at your assets 5 years prior to a Medicaid application to determine has any improper transfers been made. If you made a transfer 5 years and 1 day ago, then Medicaid doesn't see that transfer. That transfer was by default proper because it occurred 5 years and 1 day ago. So we frequently do that for a lot of our clients that are, elderly, or they are, they got diagnosed with an illness or, dementia, early stage dementia, and they want to protect assets. Well, we implement a gifting plan such as let's gift the house. We can gift, some money, and gifting it, you lose all ownership and control over this gift, but you just protected that asset from a potential Medicaid application if we wait more than 5 years after that transfer. Um, so I see a question here, so I'm gonna read this question here. Um, maybe you can answer this one, George. I'll read it and you answer. Um,
Sure.
my friend's husband has dementia and can only be alone for about 30 minutes at a time. The patient's wife is the primary caregiver, but their adult son lives with them and also serves as another caregiver. The adult son is also dealing with mental illness and he recently qualified for his own disability income. Can the adult son count as an adult child who lives in the home and is a caregiver? The husband who has dementia still lives at home but may need a nursing home later on. So I see like three ways to protect the
Okay.
home there.
I would have a couple questions first. Um, is one would be, um, is the son a child of the the husband with dementia? One of the things that often will trip people up is, you have a blended family, or you have a spouse who has a child, but it's not that spouse's child. That's the one that's been taken care of stepmom or stepdad. That doesn't apply. The caregiver exemption only applies to a biological child. So if they are a biological child, then then yes, there could be a child caregiver exemption. What the son would have to document is, when he started residing in the home, he would have to show what when his father met the level of care necessary for uh, nursing home Medicaid. In other words, did he meet the care criteria, needing hands-on assistance with activities of daily living, or needing 24-hour supervision due to cognitive impairment. And then he would have to document what sort of caregiving or services that son provided. And it doesn't have to necessarily be, nursing type care. If the son was, making sure that the house was kept in good shape, keeping it clean, making sure that the lawn was taken care of, that the house was in good repair, getting groceries, helping with housekeeping. If he was really, doing a lot of those things, he could qualify under the child caregiver exemption, because the idea is, was this person living in the home? Were they essential to keeping that person in the home, keeping them out of the nursing home? That's the key fact that they're looking at. So I think the answer here could be, most likely, it would depend on just the facts and what kind of care that the son was providing. Um, you know, the husband's still at home, but may need a nursing home later on. Well, you can actually, all of the Medicaid planning strategies that we are going to talk about tonight, we'll frequently refer to, okay, the person's in the nursing home, or they go into the nursing home, or things like that. But Medicaid does have home and community-based programs that have the same eligibility criteria as nursing home Medicaid. So in the community, there is the passport waiver, and there is the the Ohio home care waiver. Both of those have the same financial and non-financial criteria as nursing home Medicaid. Same 5-year look back, same asset test, same resource test, income test, and you can use these programs to do your Medicaid planning. So oftentimes we will have this transfer done for a child caregiver as part of an application for passport Medicaid. And so the individual isn't going into a nursing home quite yet, but he still meets the level of care for passport. You can use that application for passport services to get your Medicaid planning accomplished. And if somebody goes on passport, they're getting at home health services and other benefits. But then if they do need to go into a nursing home, they're already on Medicaid, which makes the process a lot easier at that point. That you don't have to do this Medicaid application and this Medicaid planning while the person's in the nursing home, racking up a very large monthly expense until Medicaid comes in and wipes it out.
The other points, though, in this question I just wanted to address was that even though the son does live there, there is the spouse that is still alive. That the home would still be exempt for the spouse. And if the son is now receiving Social Security themselves, then with disability Social Security, then the transfer can occur because that child is disabled. So, there's a lot of ways to protect the home in this example that was given that, it might be worthwhile to just don't even worry about the child caregiver exemption, because there's other ways to exempt the home. And, if both of them want to gift the home to the child because they're on Social Security, that's the easiest way to do it, is to gift it to the child or to a child's trust. That if the child is just not good with money, they're suffering from a mental illness, so you want to have more protection. Well, maybe a trust for the child that's on this receiving disability income would be a good option as well. So there's a lot of ways to protect the home in that example.
All right. So what to do? So we've been talking so far about how to keep the home as a home. For somebody to live there, whether that's a spouse, whether that's a dependent family member, or one of these exempt transfers to a child or other person. But a lot of times people are going to sell their home when they're moving into a nursing home or what have you. So what's the best way of going about that? What can be done to protect and preserve the value that they receive for selling their home? So like Ethan talked about, it's an improper transfer if you don't receive fair market value in return for that sale. So we unfortunately we see this a lot where people get burned because they want to get rid of the house as quickly as they can. The house may need a lot of work. It may need a lot of repairs. They just don't, whoever is handling things, an adult child or a spouse, they're just not up for, putting the house on the market and showing it and getting it fixed up for sale. But they have a neighbor who says, I will, I'll buy the house from you for the amount that you owe on it. So you might have a $200,000 house that you owe $70,000 on. Beware that neighbor that wants to give you the $70,000 and call it even, because Medicaid is going to want to see that house sells at fair market value. If it doesn't, and you can't show that the price, that the sale price was the the market value, the difference between what you sold it for and what its market value is going to be penalized. So we see this a lot because, you know, it's a double whammy, because not only are you taking this penalty on on selling the house, you're not getting actually any benefit from it. It's one thing to say, okay, you transfer an asset that you are going to take a penalty on because that asset's still there. You transferred it, but it's still there, whether it's cash or property or what have you. But when you sell something at below market value like that, well, now you've got to do a penalty. You got to take a penalty, and you're out the full value of the resource that you parted with. So it's really, really important in the context of selling a house for somebody who is going to be going into a long-term care situation that you get fair market value for it. There's companies out there, realtors, real estate companies that will take the lead on fixing up and selling and showing the house. They're worth their cut of the proceeds, because you're going to make sure then that you're going to get fair market value for the house. You're going to get the most that you possibly can for it. There will be an appraisal done as part of the sale. That's really important. So beware all cash sales or handshake deals, things like that, because you can really, really get yourself into trouble by doing that. Now, we're going to talk about later doing a short sale as part of a planned gifting strategy. Now that's something different. If you're doing something deliberately like this, then that's a different story. But always make sure that you are keeping your eyes open when you are selling a house, for somebody who's going to be going into a nursing home. And that really goes for any asset, but it's just the fact that houses have such a high value. You really see the impact here if you're not careful. All right, you can hit the next slide, Ethan. So how does this work when the home is exempt and then it gets sold? Because while it's still the home, it is not countable as a resource for Medicaid. But then when you sell the home and you transform it into this big bag of money now that you have, how does Medicaid evaluate that? How do they look at that? Medicaid is going to consider the proceeds that you get from the sale of the resource as a countable resource in the month after you receive them. So whatever you're going to do with those proceeds, it is better to have more time to do it than less time. And it's calendar month by calendar month. So it's better to close at the beginning of a month, or at the very least, not at the very end of the month, if you at all can, if you can control that at all. So, for example, if your sale closes on June 28th, and the proceeds are deposited into your account on June 29th, Medicaid's going to consider them a countable resource as of July 1st, 2 days later. So if you haven't done your planning or whatever it is you're going to do with those proceeds by July 1st and you're on Medicaid, you could lose your Medicaid because you're now over-resourced. Compare, though, the sale closes on July 2nd, the proceeds are deposited on July 3rd, you've got all the way until the end of that calendar month, until August 1st, before Medicaid's going to consider them as a countable resource. So that's plenty of time if you're going to be doing an asset protection trust, or you're going to be, doing spend down, or you're going to be, doing any sort of Medicaid plan with those proceeds. You've got 4 weeks to get that done instead of 2 days, and it all just depended on when that closing date was and when that money came into your hands. So, these are things you can make it easier for yourself, save yourself some stress. Again, to the extent that you have the control over things, have a closing date in the first week of the month rather than the last. So how does this work then? So yeah, they're accountable in the month following the sale. In general, this is just sort of the general Medicaid rule. If those proceeds now make you above the resource limit, then Medicaid will stop until those proceeds are spent down or otherwise dealt with. You can deal with that by doing a gifting plan, or using the proceeds by putting it into a trust. But that's, if you don't do it with some deliberate understanding of what the impact is going to be, you could get yourself into a difficulty by having that be a penalized transfer. I see that there's a question here. What if the home sale resources are used to buy another home? Well, there is a home replacement exclusion. And if you use the proceeds from the sale of one exempt resource to purchase another exempt resource, then you can, that new exempt resource will continue to be exempt. So, if you are doing, selling one home, purchasing another, you're going to, again, your timing here is going to be, important. If you can have it such that you receive your proceeds from your one sale and then, transfer them, purchase them, use them to purchase that other home, your second home, your new home, within that same calendar month, then you're fine. There's no harm, no foul. Those proceeds were never considered accountable. So I do know that there are some other specific rules about this. It's been a while since I had the opportunity to look at them in detail. I don't know, Ethan, do you have any working knowledge? I know there's the rule about there's the home replacement exclusion, but I honestly, it's been so long, I haven't had an opportunity to look at it.
Well, you're right. I mean, that this scenario doesn't really come up too often, because if you're selling the home, it's because you are in a nursing home. But if this one big point about that is if you purchase a new exempt home and there's cash left over from the new purchase, that leftover cash is not exempt. So you have to do something with that. You need to spend it down. You need to incorporate it as part of the plan, of, if we're going to gift it, if we're going to spend it on your care, spend it on other exempt resources, we've got to do something with it. But this doesn't really come up too often. There are scenarios where this would come up, I guess, where they are receiving that in-home Medicaid, passport Medicaid, where you just want to downsize. Maybe you're in a big house and you want to move to a condo, so you have less to do, around the home.
And Ethan, I did just take a quick look at that home replacement rule. So if you're going to be using those funds for purchasing another home and related expenses, you actually have 3 months from the month that you receive the proceeds to use them for a home, for a new home. So you get a little bit of a longer period of time to where those proceeds aren't going to be considered accountable resource to do that. But that's only if you are going to be using those proceeds, and you have to be able to show that. The rule here says they're excluded when they are used or obligated to purchase and occupy another excluded home. So in other words, you've got to You've got to show that these proceeds are going to be used for another home in some enforceable you know you know bona fide way. You can't just say, oh well, I'm going to buy another home. You've got to show you've got under contract
Yeah,
to
you're
to purchase.
actively, yeah.
Yeah, you're actually purchasing another home, but you get a little bit of extra time then to do that if you're going to be buying another home.
So what can be done then to, protect that cash after we sell the home? I mentioned this just a little bit ago. You do a proper spend down of the cash, of the proceeds, and that would be, paying back debt. And we said including to family. If you're paying back debt to family, that, hey, your child or your brother lent you $20,000. Well, yeah, that can be, paid back to them, but with the caveat of we need to we need to make sure that this is a verifiable debt, that you can't just say, yeah, they lent me money years ago, but you know there's no proof of that. The county, they need some kind of documentation to prove of that debt. Credit card bills, that's easy. You have the statement that you can say, yeah, I owe $10,000 to Visa, $15,000 to Discover. But, you know, when the loan is from a family member, well, is there any documentation proving that? Um, Other proper spend down techniques is, purchasing a new home. We just said that, but also purchasing a new vehicle. Prepay your burial and funeral costs. Those are big items that are exempt that you can use. As long as the burial and the funeral costs are irrevocable, meaning that when you go to the funeral home to prepay, the contract that you sign has to include the words that this is irrevocable. You can't go back the next day and say, no, I changed my mind. I want my money back. It has to be irrevocable. And just other personal items that one needs, if that's a new bed, if that's new furniture, clothing, um, or any medical devices, a new wheelchair, anything that would help that person medically. Those are exempt resources that are allowed to be spent down. Um, Other exempt transfers, and we mentioned this, if a child is disabled, well, that can be transferred to that child or to that child's trust. Um, and that trust has to be for the sole benefit of that disabled child. Um, there's also pooled trusts that people use, where these pooled trusts are Medicaid payback trusts. So if a client says, well, yes, I'm going to a nursing home, but I want to have access to my funds um, in order to help me out, as I'm in the nursing home. I still believe that I have 5 more years left on this earth, and I want to make sure that we can use these funds for my benefit. Well, it can go into this pooled trust, which is an exempt trust. It's an exempt transfer to the trust. The big caveat to this type of trust, though, is that there's a Medicaid payback on this trust. So any funds that are left over in this trust at a person's death would be paid back at death, to the amount of Medicaid benefits that Medicaid has given this person. So it doesn't really help in protecting money for family members, but it's there to protect the individual that is, um, on Medicaid, so they can use this money for their benefit while they're still here. But, you know, what if we want to, you know, protect this money for, you know, for other family members, or spouse, or, you know, even children? Well, there's if a person is married in a, in a spousal Medicaid application, any assets that an applicant has can be converted into a special annuity called a Medicaid compliant annuity. And I'll get into that in the next slide, because I more properly define it in the next slide. But essentially, you can take an asset, convert it to an income stream for the community spouse. Or if there is no spouse, we can gift part of the money to family members, to children. The other would have to be put into an annuity for the applicant's benefit to pay for their care as a result of making an improper transfer. So if you have $100,000 from selling the home, you can take that $100,000 essentially and gift half of it. The other half would have to be put into an annuity or a pooled Medicaid payback trust to pay for that penalty period that the person will be on as a result of that gift. So you can't save it all, but you can save a big chunk of it. Um, so we threw out some terms here, and I feel like it's proper to just go over these terms a little bit more in detail. So first, the first term here of revocable trust. This is typically where the settlor, the person creating the trust, the trustee, the person that is managing the trust, and the beneficiary of the trust is usually the same person. This is used for estate planning purposes, where you own all your assets and you want to fund a trust at your death. And so at your death, your assets are transferred to a revocable trust for the benefit of your children. And it's split however the trust says. For Medicaid purposes, if you have a revocable trust, Medicaid sees a revocable trust as a see-through instrument. They see right through the trust, and anything that the trust owns, the Medicaid applicant owns. So the the trust is not a revocable trust, is not used at all for Medicaid purposes and Medicaid protection. But then the irrevocable trust we do use for Medicaid purposes. So this is where the settlor is the Medicaid applicant, and the trustee and the beneficiaries are typically the children. It doesn't have to be, but in this scenario, in most scenarios, that's typically the case. So we use this as part of our 5-year gift and wait plans or other gifting plans, where we're gifting assets to an irrevocable trust. We're making a completed gift, and that is an improper transfer, but we're doing that for a specific, purpose, and to protect the asset, whether that's the home, whether that's cash, or a mix of the two. The pooled Medicaid payback trust is also an irrevocable trust, but the trustee is an institution. It's a bank, but the trust advisor of the pooled trust is a nonprofit organization. The nonprofit organization is the manager of the trust. They have to go through federal regulations and Ohio regulations in order to have a pooled trust established. There's only two pooled trusts in the state of Ohio. One is the Dayton Foundation, and one is Community Fund Management Foundation. Community Fund is in Middleburg Heights, in our neck of the woods. Um, but either one of those two trusts, a transfer to a pooled trust would be exempt, and the assets are exempt. As I said before, the Medicaid is the first beneficiary of the trust money. So it's a Medicaid payback trust, essentially. The other term here that I used prior is this Medicaid compliant annuity. This is a special annuity that we use um, for Medicaid applications, where creates an income stream either for the applicant themselves to pay for their care or to the spouse to protect assets. This annuity is not an investment tool at all. It's simply, we're converting assets to an income stream. And there are special nuances to this type of annuity. The major ones are the annuity must be actuarially sound. What that means is the annuity has to pay out according to this person's life expectancy. Life expectancy is determined by Medicaid tables. And what that means is if you look at this person's age, and according to the Medicaid tables, they have 5 years left to live. You can't make the annuity 6, 10 years, 20 years as a payout. It has to be less than that person's life expectancy. It has to be actuarially sound. It has to be an immediate pay annuity with no balloon payment. So that means that once you fund the annuity, it has to pay out immediately. It has to pay out that next month. And it can't pay out in small increments, and then at year 5 it can't pay out this big huge payment. It has to be equal payments throughout the term. The state of Ohio is also a contingent beneficiary on this annuity. So if the person dies, the annuitant dies while the annuity is still paying out, Medicaid is the beneficiary of whatever's left in this annuity. It will be paid back to the state of Ohio. So there's other nuances to it. Those are the big points of this, but these are the tools that we use as part of gifting and Medicaid protection planning. We use these trusts, irrevocable pool trusts, and these annuities in order to protect these assets. And George, you can take this one.
Okay. So somebody who is unmarried, what can they do as far as protecting their assets, whether this is protecting just keeping their house, or just keeping the proceeds from the house or their other assets. And if we don't have an exempt transfer available, if we don't have a caregiver child, if we don't have a disabled child or a spouse, something like that, we're looking at doing what I call a split gift plan. And Ethan has kind of talked about this. You split the amount of assets that you have. You gift a portion of them, and you set another portion aside to pay for care while you are waiting for that Medicaid penalty period to run. So in this example, our applicant has $200,000 in cash, and then a house that has a auditor's value of $200,000. In this scenario, for example, what is the goal here is, we want to keep this house. This house has been in the family for generations. We want to keep it in the family. The children, there's somebody who wants to live there. We don't want to sell this house. It's too important. Luckily, the house itself can be gifted to the children. This, if there's $200,000 in equity in that house, then Medicaid's gonna say, well, because you transferred that house, we are not going to pay for the nursing home for the next 26 months. We don't care who does, but it's not going to be us. So in that scenario, the $200,000 in cash would be needed to be placed into either one of those Medicaid annuities or into a pooled trust. And that, combined with the applicant's monthly income, would need to be used to pay for their long-term care for that next 26 months while they're waiting for Medicaid to start. Now, why does that $200,000 need to be put into a pooled trust or into an annuity? Why can't it just sit in the bank and be used to pay for care for the next 2 years and 2 months? The way the Medicaid rules work, that restricted coverage penalty period, it doesn't start until the applicant is otherwise eligible for Medicaid. So if you just leave the $200,000 in the bank, then they're not eligible for Medicaid. So that clock, that restricted coverage clock, doesn't begin to run. So if you transferred the house and then 26 months later, after you've spent the other $200,000, then you apply for Medicaid, you've put yourself in between a rock and a hard place, because now that 26-month restricted coverage period is going to start, and you don't have any money left to set aside to pay for care. So when we're doing these split gift plans, timing is really, really important, because we want to make sure that we are setting enough money aside that we can pay for that care over the next however many months. But we've got to get that person otherwise eligible for Medicaid. So that means, doing something with those funds where they're no longer going to be a countable resource. So that's putting that into a pooled trust or putting that into an annuity in order to get that clock ticking, in order to make the plan work.
And the other, beauty of this technique is, if the home doesn't really have the family doesn't really care about the home, but you're trying to protect assets. Once again, we're using the auditor's value of this home. So if you transfer the home worth $200,000 to a child, and the child then turns around a couple months later and sells it on the open market and receives $250,000, Medicaid doesn't care about that $50,000 gain that just occurred. They care about the $200,000 transfer, because the value of the home in their eyes is $200,000. So instead of flipping this around and saying, I'm going to gift $200,000 in cash to my child, and we're going to sell the home, and you sell the home for $250,000, well, you just lost out on a big portion of cash assets to protect. So that just highlights that, hey, Medicaid only cares about the auditor's value. If the home is going to be you receive a larger value by selling it on the open market, that's okay. Medicaid only cares about the auditor value. A couple questions came up here. Is a special needs trust subject to a Medicaid payback? The a first party special needs trust is subject to a Medicaid payback. That is, a person's own money can be set aside, in a special needs trust. And if it's their own money, it has a Medicaid payback. Um, the third party trust is your money, you know, grandparents' money, setting it aside for a disabled child or grandchild. That is not subject to a Medicaid payback. So it depends on who's creating the trust and, who has access and control over that money. That determines whether there's a Medicaid payback, you know, in the trust. Um, Another question was, I've created a trust account for my disabled adult child who is on a Medicaid waiver. I purchased a home for her, titled it to the trust, so that if it's ever sold, proceeds go to the trust. Will it protect it from Medicaid recovery for either of us? Um, yes, if the trust is a third party trust, number one, in that scenario. If you purchased a home and if you purchase a home for a disabled child and it's in a trust, whether that's a first party trust or a third party trust, because this child is disabled, it is protected because a transfer to a disabled child or disabled child's trust is an exempt transfer. Um, okay, so let's go to the next example here.
Okay. Now, let's say we don't have an excess amount of cash here. We only have our home. There's a $200,000 house, but minimal liquid funds. We see this quite a bit. The applicant is going to be going into a nursing home. The family wants to protect the house, and they want to be able to get value out of it, and they don't want to lose it to Medicaid estate recovery down the road. But one of the things that could be done is if somebody in the family could purchase the house at fair market value, then that's okay. There would be no penalty there. Unfortunately, and more likely, it's unusual for a family member to have the ability to take on another house payment, or purchase the house outright at fair market value. But perhaps the family or some of the siblings could manage to put some money toward it. They could put up, they could combine, they could get financing, or they could come up with 100,000 to put towards that house. They could give their parent their $100,000, and the parent in return would gift them the house, or transfer the house to them. Now, Medicaid's going to penalize that other $100,000 as gifting that equity to them, but that's only going to be a penalty of 13 months thereabouts, as opposed to gifting the whole 200,000, which is going to be over 2 years. So that 100,000 now can be used to pay for that care during that 13-month period. And at the end of the process, now the family has a house that was worth, in terms of Medicaid value, $200,000. But as Ethan pointed out, they could then turn around and sell for $250,000 or more. So if that's going to be your scenario, you can really see how even by taking that penalty on transferring the house at below market value, you can still come out ahead. I can give one war story about how this works. I once had a case where the the applicant, they actually, it wasn't their home, they had a vacation house, a lake house in Michigan. And I think this has changed now, but at the time, the way Michigan law worked, the county auditor only revalued the house when it transferred ownership. And this house had been purchased, this lake house had been purchased decades ago. So its value, when you looked it up on the website for the Michigan County, its value was like $25,000. We transferred that into the Irrevocable Trust. They ended up selling it for $200,000 because of the increase in value over the years. And they only took a $25,000 penalty on it. That was just, we were definitely pleased with that outcome there. Usually you don't get that, but it goes to show you, whenever we have a house that we are looking to, if the plan is to sell the house, we always will look to see can we gift this house first, because it's free money. You're getting extra value that you're not taking a penalty on. If you can do that, then there's absolutely no reason not to. So go ahead,
Yep.
Ethan.
So Medicaid estate recovery, this is when you own assets at death. Medicaid, the state of Ohio, can come after those assets if the Medicaid recipient still has ownership of those assets. So you see this a lot with nursing home residents. They still own the home. They pass away. They've been in the nursing home for years, and their $200,000 house that they had, well, now Medicaid comes in, the state of Ohio comes and puts a $500,000 lien on that house to, recoup those Medicaid benefits that were given. The Medicaid estate recovery is throughout every state. Each state then has rules and nuances, depending on those regulations. Unfortunately, Ohio has expanded Medicaid estate recovery. Some states only attach to probate assets. Ohio attaches to probate and non-probate assets. So what does that mean? Well, the next slide here is the revised code statute explaining what an estate means. Well, it's the 1A deals with, your estate, your probate estate, and 1B deals with the non-probate estate. So an example here is if you own a home at death and you have it transferred on death to a child or to a trust, well, Medicaid is going to say you had this, and even though you had a beneficiary attached to this asset, this house, we're going to attach a lien to this property. It's expanded, and that deals with any asset that one owns at death. That includes, the house is the big one, but that can include vehicles. It can include a retirement account. A retirement account is typically exempt for a person being on Medicaid if it's in payout status. So we're getting into the weeds here, but I always typically count the retirement account because of Medicaid estate recovery. I typically include the house as part of, as part of the assets to protect because of Medicaid estate recovery. even though it's exempt while this person's alive, Medicaid can attach to it when this person passes away. Um, the what happens when someone passes away? Well, and they own the home. Many people think that the home is subject to it's subject to um, foreclosure. Well, it's not a foreclosure proceeding. It's simply they're going to put a lien on this home, or they're going to request that the beneficiaries pay them. And if they can't pay them, then they put a lien on the home. That's typically how it works. Um, they can't. They're not going to force a sale, and claims cannot be enforced if the spouse is still living, and a claim cannot be enforced if the caregiver child lives there. Um, so there's exceptions to the Medicaid estate recovery. There's a question that came up. What about money in a special needs trust? Would that be attached by MER after the Medicaid estate recovery after a person dies? The Medicaid estate recovery is different from the Medicaid payback in a trust. In a special needs trust, it's a contract essentially. It's an agreement that with the government that I'm going to put this money aside in a special needs trust, and the if I die and there's money left over in a special needs trust, that money will be paid back. We're talking about assets in Medicaid estate recovery that the individual owns. It can still be paid back to the state, even though there's no trust involved here. It's just the individual owning that asset.
Okay, I'll bring it home here. Um, just to jump off where Ethan was, you know, there's there's a lot of ways of Medicaid being paid back with what we're talking about. Usually, almost universally, if the person is going to be setting aside their own money in some way that is not going to be required, that Medicaid's not going to require them to spend down to get Medicaid while they're alive, is going to have a Medicaid payback arrangement at their death. So whether that's a pooled trust, whether that's a special needs trust, whether that's a Medicaid annuity, um, you know, anytime you're setting aside your own money and getting Medicaid, there's going to be some Medicaid payback involved. That's sort of the quid pro quo there. Um, contrast, if it's somebody else's money, if you're giving your money for the benefit of somebody else who is going to be receiving Medicaid, the third party trust is not going to need to have a Medicaid payback provision. That's the key distinction there. So yeah, I see the comment here on the chat. Yes, they're a third party trust. If it's someone else's money, does not need to have that estate recovery or that Medicaid payback provision. So how do we avoid estate recovery? Well, it's very easy, actually. You transfer the ownership of whatever these assets are before that individual passes away. So whether that is by retitling things into the name of the healthy spouse, doing one of the gifting plans we've talked about, or doing an exempt transfer, so long as that individual, that Medicaid recipient, does not have an ownership interest in that property at their death, then there's no estate recovery. So the sort of the bog standard kind of thing that we do is you have a married couple. They own the home. They're joint and survivor on it. One of them is going into the nursing home, is going to need to get Medicaid. One of the first things we do is we get a new deed drawn up that transfers the one half ownership interest from the nursing home spouse over to their community spouse. so that now the house is only in the name of the community spouse, so that when that institutional spouse passes away, there is no Medicaid estate recovery. There's no lien. There's no nothing. What we will have then the healthy spouse do is put a transfer on death designation to have that house passed directly to the kids. So if something happens to the healthy spouse first, you don't have that reverting back to the Medicaid spouse and undoing all of your planning. But that's the key. Medicaid estate recovery has a claim against anything that the individual, the Medicaid beneficiary owned at the moment of their death. So whether that is something that's passing through their probate estate, or whether it is going by transfer on death, if they held it at the moment of their death is when Medicaid estate recovery attaches. If they get rid of it a week before, if their name comes off of it and then they pass, then there's no estate recovery against that asset. So just to kind of sum it all up here. So exempt resources. These are resources that you don't have to spend down in order to get Medicaid. Those assets can be there and are available for that person during their lifetime, but they're going to be subject to Medicaid estate recovery at their death. The way that you avoid that is you can transfer those assets to a spouse as part of the community spouse's resource allowance while you're applying for Medicaid. And then, or if that person does not have a spouse, there can be a plan done where these assets are going to be gifted, whether this is going to be an exempt transfer or one that is going to involve a penalty that we have to plan around. So long as we transfer those assets outside of their death, they won't be subject to Medicaid estate recovery. I see a question here. Would this need to be done 5 years before the transfer? So the 5-year rule applies to transfers that would otherwise be improper transfers. So by way of saying, if you wanted to gift your house to your child who is not disabled and not a caregiver child, you would need to transfer that 5 years before you applied for Medicaid, because otherwise that's going to be a transfer that's subject to a restricted coverage penalty. What we're talking about here in terms of estate recovery, like between spouses, transfers between spouses are specifically exempt from the transfer penalty rules. So you don't have to do a 5-year plan to move everything over to your community spouse. In fact, you can transfer those assets even after you are on Medicaid to avoid estate recovery. So if you have a husband and wife where the institutional spouse gets on Medicaid, and then 6 months later they transfer by deed their half of the house over to their spouse, that's fine. That's not going to cause a problem for estate recovery or a Medicaid transfer. So the 5 years is about what's gonna happen when you apply for Medicaid if you've made transfers that aren't exempt, but it doesn't have any bearing on Medicaid estate recovery. Okay.
All right.
So,
well, that's all we got for you folks. Thank you for your time here, and hopefully we set your mind a little bit at ease. It's a complicated world with Medicaid. If anyone has any further questions, feel free to reach out to us. Anyone in our office will be happy to answer any questions, any further questions. With that being said, have a great night and talk to you soon.
take care, everyone.